Okay. Okay, we'll go ahead with the case then. Suit number NICNL 439 2022 between Mr. Chandria Shankaruddin and EBM Systems Nigeria Limited. The claimant approached this court via the general form of complaint and statement of fact, both dated the 22nd day of November 2022, seeking the following reliefs against the defendant, to which: one, a declaration that his termination was unlawful and not in accordance with the employment contract dated 29 June 2021. A declaration that the claimant's employment with the defendant is still valid and subsisting on the basis that his contract was terminated. An order directing the defendant to pay the claimant the sum of $4,000 monthly from the month of December 2021 until the termination of this suit. An order directing the defendant to remit all outstanding tax payments of the claimant to the tax office in accordance with the employment contract, and the sum of 1,250,000 naira being the cost of litigation of this action. The claimant's case is that Mr. Chandrai Dane was employed by the defendant on the 1st of August 2021 as a CFO on a monthly salary of $4,000. The defendant's company closed for Christmas and New Year holidays on the 23rd of December 2021, with a resumption date set for the 17th of January 2022. He traveled to India, and the MD of the defendant paid his ticket fare to India as it had been previously orally agreed between parties. While in India, Mr. Dane became unwell and suspected he had COVID. He communicated same to the MD of the defendant, and he was told to stay back in India and work remotely till he became better. That Mr. Dane returned to Nigeria on the 31st of January 2022 and resumed work same day. On the 17th of February 2022, 7 months after his employment, he was orally informed by the defendant that his services were no longer required. His salary for the months of December 2021, January 2022, up till the 17th of February 2022 was outstanding. He was owed $10,000 by the defendant. The defendant, however, unfairly insisted that it would only pay the sum of $4,000 to him, and afterwards made part payment of 1 million naira. He wrote to the defendant asking for the remaining sum of $3,349. The defendant's case is that the claimant absconded from his duties as a chief financial officer, CFO, in the defendant's business while still on probation and in breach of the defendant's employment policies. While in employment, the claimant failed to exhibit utmost devotion and commitment to his work as expected of him. The defendant had on several occasions orally called the claimant to order with respect to his lackadaisical attitude towards work and gross abuse of the privileges accorded to the claimant. That the claimant failed to diligently carry out functions required of him by the defendant, and that the claimant was inefficient and ineffective at work. That the claimant implored the defendant to grant him a loan for his flight ticket to India in the sum of 980,000 naira only, less than a year into his employment, contrary to his employment agreement, and notwithstanding the fact that the defendant was in operation throughout the said period. The claimant absconded to India on the 22nd day of December 2021 till February 2022 when he returned. The defendant was indeed surprised when he resumed work and was not obliged to issue him any written notice of termination in view of the breach. That it is on the basis of these abridged facts that the claimant approached this court and sought the reliefs as contained in his general form of complaint against the defendant. The defendant sought some counterclaims against the claimant dated the 27th of January 2023. One, the declaration that by virtue of the defendant's counterclaim claims breach and termination of his employment agreement dated 29 June 2021 by proceeding on his undue self-approved leave on the 22nd of December 2021, together with other infractions, there exists no employment relations between the defendant to counterclaim and the counterclaimant. A declaration that the defendant to counterclaim is not entitled to any salary nor remuneration whatsoever from the counterclaim, having by himself terminated the employment agreement between parties. A declaration that the defendant to the counterclaim is indebted to the counterclaimant to the tune of 980,000 naira, being the sum expended on the claimant's ticket for his self-approved leave, and a declaration that the defendant to the counterclaim is indebted to the counterclaimant to the sum of 1 million naira only, being the loan advanced to the defendant to the counterclaim by the counterclaimant on the 31st day of May 2022, which remains unpaid as at the date of filing this claim. And order that the liquidation of the loan sum of 980,000 naira for the purchase of the defendant to the counterclaimant's flight ticket with interest at the prevailing fixed deposit rate of commercial banks until full liquidation of the loan sum by the defendant to the counterclaim. And an order for the liquidation of the loan sum of 1 million naira advanced to the defendant to the counterclaim with interest at the prevailing fixed deposit rate of commercial banks until full liquidation of the loan sum by the defendant to the counterclaim. Thereafter, the claimant filed his reply and defense to counterclaim dated 18th of October 2023. At trial, the claimant gave evidence as CW1. The defendant's sole witness was one Mr. Luis Uchenna Njoki, DW1. The following exhibits were tendered at trial: Exhibit C1 to Exhibit C10, and the defendant's documentary evidence were admitted and marked as Exhibit D1 to Exhibit D5. The details are all embodied in the body of the judgment. I'll not read the defendant's final addresses and all the arguments. They are all embodied in the judgment. I'll go straight to the decision of the court. The court's decision. I read and understood all the processes filed by the parties on either side. I heard the oral testimonies of the witnesses called at trial and watched their demeanor. The exhibits tendered and admitted at trial has been evaluated as well as the oral argument of learned counsel on either side at the point of adoption of final written addresses. The claimant is seeking for declarations that his termination was unlawful and not in accordance with the employment contract dated the 29th day of June 2021. Therefore, his employment is still valid and subsisting on that basis. The state of the law remains straight that it is for he who asserts to prove the assertion by adducing credible, cogent, and admissible evidence in support. Sections 131 and 132 of the Evidence Act 2021 provides to that effect. A plethora of judicial decisions from the appellate courts, for instance, Dasuki versus Federal Republic of Nigeria and others, Ogbere versus Ukpo, citations all provided are in support of these statutory provisions. Thus, the claimant in the instant case is under an obligation to exhibit his employment agreement comprising the terms and conditions of his employment and draw the attention of the court to how the termination of his employment was unlawful. The claimant, in proving the wrongfulness of the termination of his employment, aside from affirmance in his pleadings, tendered 10 exhibits. The claimant is saying his employment was terminated outside the 6 months period. Therefore, the defendant company should have issued him with a notice. To establish that he served beyond 6 months, he tendered his employment agreement, which is the basis of the employment relationship. His employment commenced on the 1st day of August 2021. As stated earlier, the employment contract Exhibit C1 provided that the defendant could terminate the employment without a 1-month written notice within the first 6 months of his employment if there was a material breach of the employment agreement as contained in paragraph 8.1 sub B of the agreement. In the claimant's statement of facts in paragraph 3, he stated that there was a contract of employment dated 29th of June 2021. In the witness statement on oath paragraph 3, he said that he was employed on the 1st of August 2021 as CFO on a monthly salary of $4,000. In paragraph 5, he stated that the defendant company closed for Christmas and the New Year holidays on the 23rd of December 2021 and set a resumption date of 15 January 2022. And he tendered Exhibit C2, which is the Excel sheet showing attendance at meetings during the leave period. The dates reflect 13th, 15th, 17th, 18th, 20th December 2021. It also reflects 20th, 21st, 22nd, 24th, 25th, 26th, and 29th. Sorry. It also reflected the 20th, 21st, 22nd, 24th, 25th, 27th, 28th, and 31st of January 2022. He stated in his witness statement the 1st of January 2022, but he resumed late due to illness on the 31st and was told his services were no longer needed on the 17th of February 2022 without a written notice after spending more than 6 months in employment. On the other hand, the defendant stated that the employment contract was terminated the day the claimant traveled to India, which is the 22nd of December. The court noted with interest the events that led to the claimant's journey to India, to which the defendant proceeds in paragraph 13 of his witness statement of oath that the claimant terminated the employment agreement by traveling out of the country from the 24th of December 2021. The employment contract Exhibit C1 clause 8.0 provides that the employer is at liberty to terminate the employment by giving one written notice. However, that one written notice will not apply at the first 6 months of employment nor at the renewal point. Secondly, he can terminate with or without notice at any stage if there is a material breach of the agreement. Thirdly, even if termination is due to proven commission of serious criminal act or breach of fundamental conditions of the agreement, the termination shall be immediate without notice. In a bid to determine the actual date of termination, the court had to look at the testimony of GW1. He was asked, and I quote, "How was his employment terminated and what date?" Answer: from the time he left on the 22nd of December 2021 and traveled out. At that point, his employment was terminated. He was also asked how. His answer was, it was terminated verbally by MD. The next question: so you don't have proof of his termination before this court? And his answer was, there is none. Verbal communication. In addition, in paragraph 15 of the statement of defense, the defendant alluded to the fact that the employment was terminated when he traveled without leave from the 22nd of December 2021. In fact, the defendant calculated from commencement of employment, 1st of August 2021 to 22nd day of December 2021, which is 4 months and a few weeks. Going by the employment contract, Exhibit C1 clause 8.0, the claimant is not entitled to a notice. In O2 versus William, 1996, for Nigerian Weekly Law Report, part 440, page 56, the Court of Appeal held that once a document has been tendered as an exhibit, the court has a right and a duty to refer to any portion of the document in order to arrive at a just decision. Exhibit D6 is an invoice showing that the defendant remitted 980,000 naira on the 17th of November 2021 to the claimant for his flight ticket to India. This remittance was done 3 months and 16 days into the claimant's employment. Going by paragraph 6.0 of the employment agreement, the claimant was unqualified for leave. Why was the ticket sum approved and released by the defendant when claimant was not yet matured to embark on leave? In paragraph 5 of the claimant's witness statement of oath, he deposed that he traveled on the 24th of December 2021. However, GW1 deposed in paragraph 11 of his witness statement of oath that he traveled on the 22nd of December 2021. The flight ticket or stamp of the boarding pass was not tendered to enable the court to determine the actual date of departure. Be that as it may, parties agreed the claimant did indeed travel to India. The fact that the employer remitted the sum of 980,000 naira for his flight ticket to India, when by the employment agreement he was not yet mature to embark on his annual leave, leaves this court with no option but to be convinced that the MD had by his conduct given approval to the claimant to embark on his journey in December 2021. The implication of this is that the defendant condoned the provisions of the employment agreement by its conduct, The Supreme Court in DMP Nigeria Limited versus NPA 2019, One Nigeria Weekly Report, Part 1654, 163, held that when one party has, by his words or conduct, made to the other a promise of assurance, which was intended to affect the legal relations between them and to be acted upon accordingly, then, once the other party had taken him at his word and acted on it, the one who gave the promise or assurance cannot afterwards be allowed to revert to the previous legal relations as if no such promise or assurance had been made by him. He must accept his legal relations as modified by himself, even though it is not supported in point of law by any consideration, but only by his word or conduct. Put differently, whatever a man's real intention may be, he is deemed to act willfully if he so conducts himself that the reasonable man would take the representation that he should act upon it and did act upon it as true. This is the common law principle based on equity. See Ude versus Suji, citations provided. The defendant is therefore stopped from feigning ignorance of the claimant's journey and his absence at his place of work, which is Lagos, Nigeria, as stated in clause 1.4 of Exhibit C1. Having granted him approval and acquiesced to his departure to India, can the employer terminate his employment? Paragraph 10 to 13 of the Statement of Defense, which comprises the material breaches of the employment contract, fall flat because the employer waived those aspects of the contract by approving the remittance of 900,000 naira as flight ticket only 3 months and 16 days into the claimant's employment. This court is of the view that for the defendant to state, and I quote, categorically, that the employment agreement between parties stands terminated from the 22nd day of December 2021, when the claimant was absent without leave, thereby breaching the employment contract, end of quotation, was wrong. It is established that the employment was not a statutory contract, which would have translated to an unlawful termination. I hereby declare that this termination was wrongful, not unlawful, I so hold. In the case of Obanya versus UBA PLC, citation provided, the Supreme Court held that the remedy open to the employee in cases of wrongful termination of employment by his employer and recognized by law is a claim for damages. And the law is now firmly established that the quantum of damages a claimant would be entitled to is a sum or amount of money to be paid in lieu of the requisite notice for the proper termination of the employment. The court, however, noted that damages was not sought for by the claimant, since it is the law that the court will not grant a relief which has not been sought or asked for by a claimant. See Okubule versus Oyagbola, citation provided. I shall move over to the next relief sought. The claimant is also seeking for a declaration that his employment is still valid and subsisting on the basis that the employment was not terminated. The claimant stated in paragraph 10 of his witness statement on oath that on the 17th of February 2022, he was informed his services were no longer needed without a written notice. In response, the defendant in paragraph 1 of his statement on defense stated that he denied paragraph 10 of the claimant's statement of fact and put the claimant to the strictest proof. There was no further evidence to controvert the date of 17 February 2022 as the date claimant was informed his services were no longer needed. DW1 in his witness statement on oath from paragraph 17 to 19 also did not controvert this alleged date. Rather, he stated the following: that defendant was surprised by the claimant's return to the company. The claimant was reminded of the breach of the employment agreement. Therefore, the employment agreement stands terminated from the date he traveled to India and was absent without leave. In response, the defendant in his statement of defense, paragraph 14, stated, and I quote, the defendant was not obliged to issue him any written notice as contained in paragraph 8.1 sub B of the claimant's employment agreement dated 29th of June 2012, which provides that, and I quote, this 1 month notice will not apply at the first 6 months of employment, end of quotation. From the exhibit standard, exhibit C1/D1, the employment commenced on the 1st of August 2021, and he was told his services were no longer needed on the 17th of February 2022. The employment of the claimant was not a statutory employment. The defendant did not controvert the fact that he resumed work on December 31st, 2020. He only stated that the defendant was indeed surprised by the claimant's return to the company in February 2022. The court also noted that Exhibit D2, which was a letter dated 5th April 2022 to the Nigerian Immigration Service, requesting the Consul General to remove the claimant's name from its expatriate quota positions and releasing the defendant's company from all immigration responsibility, was also silent on the date the claimant left its employment. Facts uncontroverted are deemed admitted and are liable to be acted upon. See Jim Jaya versus COP 2011 to Nigeria Weekly Law Report Part 1231 375. In the circumstance, the court is convinced the date of termination was 17th February 2022. The claimant had therefore spent a total of 6 months and 16 days. This court therefore declares the employment was only valid from the 1st of August 2021 up to the 17th day of February 2022. The claimant was therefore entitled to a written notice as at the 17th of August 2022, I so find and home. The claimant is seeking an order directing the defendant to pay the sum of $4,000 monthly from December 2021 to the determination of this suit. The claimant did not tender any evidence of salary paid to him throughout his employment. The only reference made to amount of salary agreed upon was in paragraph 3 of the claimant's witness statement of oath and in paragraph 6 of the defendant's witness statement of oath, which is $4,000. In addition, in paragraph 25 of the defendant's witness statement of oath, he stated that the salary was paid in cash. This was not controverted by the claimant. The claimant in paragraph 12 of his witness statement of oath stated that he had not been paid for the month of December 2021, February 2022, up till 17th of February 2023, bringing the total sum to $10,000. According to him, in the process of demanding for a salary, the MD unilaterally agreed to pay $4,985 only, and consequently, on the 11th of June 2022, he paid the sum of 1 million naira at the exchange rate of 609, which amounted to $1,640, leaving an outstanding of $335. This was clearly calculated in Exhibit C8. In response, the defendant, in paragraph 36 of his witness statement, stated that out of goodwill, he paid the claimant for work done prior to 22nd of December 2021, and for virtual meetings and handover activities, he paid from 22nd of December 2021 to February 2022, which was when the defendant handed over its property in his possession. He stated further that he paid 1 million naira on the 31st of May 2022 as a loan to the defendant on compassionate grounds to assist the claimant in getting an accommodation. This court is saddled with the task of establishing if, in fact, the claimant worked to deserve the order in Relief C. Exhibit C2 is the Excel sheets where the claimant claimed he attended virtual meetings during his stay in India. The court noted the position of the defendant in paragraph 23 of the statement of defense and witness statement of oath that the defendant, and I quote, only joined meetings virtually, showing forth no serious commitment as expected of him and no meaningful contribution into such meetings. In paragraph 26 of the defendant's witness statement of oath, the defendant then stated that he paid the claimant out of goodwill for virtual meetings and handover activities from the 22nd of February to 22nd of December to February 2022. The amount paid was never stated, and it was silent on the mode of payment. DW1 during cross-examination was, however, evasive when he was asked. And the question went, how come claimant was attending meetings on behalf of the defendant in January 2022 when his employment was terminated in December 2021? He answered, I don't understand the meeting he was attending. He was asked again, was anybody present at those meetings? His answer, I don't understand. Defendant, on one hand, has stated that the claimant attended virtual meetings but did not contribute meaningfully at the meetings. But when he was cross-examined, he said he did not understand the meeting that was referred to. The defense of the defendant brings to mind Chinua Achebe's proverb in his book, Arrow of God, where he says, the man that brings ant-infested faggots into his hut should not grumble when lizards begin to pay him a visit. In view of the above, it is the finding of this court that the claimant indeed rendered services to the defendant company throughout his stay in India by attending virtual meetings as established from the exhibit standard and testimonies and is entitled to be paid. I so hold. The court has evaluated the testimonies and the exhibit and has noted with interest Exhibit D3, which is the transfer slip of 1 million naira to the claimant on the 31st of May 2022. This payment was made 3 months and 14 days after the claimant was informed that the services were no longer needed. and all of its property had been returned to the defendant company. Exhibit C8 is an acknowledgement of the receipt of 1 million naira and a reminder to pay the balance of $3,345. This outstanding amount is what the claimant had earlier stated in his witness statement on oath that the defendant unilaterally calculated. The defendant stated that it was a loan, but there is no evidence to corroborate this. There is no loan form or agreement specifying the amount and terms of repayment. The defendant did not acknowledge or refute the email. Even at cross-examination, DW1 was asked, did you do a follow-up email to clarify that the 1 million is a loan and not part of payment of salary owed? And he answered, the email was not addressed to me, so I cannot respond to that. He was also asked, do you know if any response was made to that email? He answered, I don't know. This court is convinced that the payment of 1 million naira was part payment for the outstanding salary, and the claimant is entitled to the balance of $3,345 only. The argument that it was a loan is an afterthought by the defendant in an attempt to pull the wool over the eyes of the court. The defendant is hereby ordered to pay the sum of $335 only as outstanding salary I so hold. The claimant is seeking for an order directing the defendant to remit all outstanding tax payments to the tax office. There is no schedule of payment or document exhibited to indicate the amount due as tax on behalf of the claimant. The court cannot speculate on the amount due or the content of a document not produced or tendered before it. See Njoku versus Dikibo. Citations provided. This relief therefore fails. The defendant filed a counterclaim alongside his statement of defense on the 27th of January 2023. The court, in its findings, has established that the journey to India was not self-approved. Neither did the defendant throughout trial show the warnings, the queries issued for other infractions committed by the claimant. No document was tendered to draw the claimant's attention to his performance falling below expectation. Thus, Relief A fails accordingly. Relief B also fails as the claimant was able to prove that he rendered services during his leave period, and the defendant collaborated by stating that the work done by the claimant was done to aid smooth handing over of duties on the defendant's wrong assumption in view of Relief A. In view of the failure of Relief A, Relief C fails, as the finding of this court indicates that the sum of 980,000 naira was given in good faith to enable the claimant travel for leave during the Christmas holiday. Relief D fails in that the sum of 1 million naira paid to the claimant was proven to be part of the outstanding salary of the claimant. Accordingly, Reliefs D, E, and F fail accordingly. The counterclaim is therefore dismissed in its entirety. The court hereby orders that the defendant pays the sum of $3,345 only. This shall be paid within 30 days. Thereafter, any sum outstanding will attract simple interest calculated at the rate of 10% per annum. I made no order as to cause. Judgment is entered accordingly. Signed, Justice Damachi. This is the judgment of the court.
Thank you very much, my lord. We are very grateful for the erudite ruling delivered by the Honorable Court. We thank the court for the short period within which this judgment was delivered as well. Thank you very much, my lord.
On behalf of the defendant, my lord, we thank your lordship for the well-considered judgment. We are most grateful to your lordship. The judgment exuded a lot of wisdom and intelligence, and we're most grateful to your lordship for that.
Okay. Thank you.
Thank you, my lord.
As the court pleases.
Okay.
Thank you, my lord.
Register.